Mr. Morris.
Good afternoon, my lords. Just before lunch, we had alighted on page 269 of the bundle, which should be section 40 of the 2016 Act.
Yes.
And this, in my submission, holds the key to this appeal, because, as I've said, the tribunal only has the jurisdiction to make an RRO, a rent repayment order, as defined by this section. Now, the opening words, as I'll call them, of subsection 42, which simply say a rent repayment order is an order requiring the landlord under a tenancy of housing in England to do something. Now, what those words do is that they contemplate but do not identify a tenancy of housing in England. They contemplate but do not identify the existence of a landlord. And in my submission, and as the Court of Appeal found, the key to identifying the landlord against whom a rent repayment order can be made is to identify the tenancy under which that person is the landlord. And as the Court of Appeal observed, the opening words simply beg the question, what tenancy? And the answer in my submission, and again as the Court of Appeal found, is obvious when one considers section 42 as a whole, starting with subsection B. Because if one reads the opening words with subsection 42B, one gets this. A rent repayment order is an order requiring the landlord under a tenancy of housing in England to pay a local housing authority an amount in respect of a relevant award of universal credit paid to any person in respect of rent under the tenancy. And the use of the definite article there is important because what it does is refer back to the reference in the opening words to a tenancy. So the opening words which identify a tenancy of housing, complemented by subparagraph B, which identifies that tenancy of housing in England as being the tenancy under which rent is paid. That is that can only be the tenancy under which a beneficiary of universal credit occupies housing. And so in a local authority case, a rent repayment order is, in my submission, only available against the immediate landlord of the occupier. And the inclusion of the words to any person in there, in subsection B, are explained simply because universal credit might be paid directly to the occupier and then passed on to the landlord, or it might be paid directly to the landlord.
That assumes that landlord under a tenancy means the immediate landlord, the person who, if it's a tenancy agreement, is described as the landlord.
Yes, my lord.
One of the submissions you have to meet is that it doesn't have that meaning.
I will come on and do that, my lord, because I suppose it's rather irresistible to run with my Lord Kitchen's cricket analogy. Mr. Fitzpatrick having come up to the stump or to the crease and bowled, really, if he's going to bowl me out, has to knock down this argument about subsection 42B. So let me come on then and address that now. Mr. Fitzpatrick says that the opening words...
Just before we leave that, if I may, in 42B, you say to any person, that might be the immediate landlord. In other words, it is paid directly sometimes to the immediate landlord. Is that right?
It is, and in the bundle behind tab 15, my lord, you'll find the regulations. So at page 405 is regulation 58 of the Universal Credit Personal Independence Payment, Job Seekers Allowance and Employment and Support Allowance Claims and Payments Regulations of 2013. And that provides that the Secretary of State may direct that universal credit be paid wholly or in part to another person on the claimant's behalf if this appears to the Secretary of State necessary to protect the interests of various people. So under those regulations, there is a power for universal credit to be paid directly to a landlord rather than just directly to the claimant of universal credit, then to transfer on.
Oh, it's not including people who may be regarded as, I don't know, cohabitees and that sort of thing. I mean, we're not talking about that.
I suppose in theory it could be, my Lord.
Right.
I think that the underlying policy is that Parliament considers that it's better for recipients of universal credit to receive money directly in order to encourage sound management of finances and to encourage them so much as possible to maintain their own affairs. Regulation 58 provides an exception to that, and it doesn't in any way limit the people to whom it might be paid. But for the purposes of section 42B, plainly in my submission, the draftsman does contemplate that it might be paid directly to the landlord.
What page was that, sorry, again?
I'm sorry, my Lord, I've taken my finger out of it. It was
405.
tab 15, yes, page 405. And the preceding regulation, or not the preceding regulation, regulation 47 is at page 403, which deals with payment to the claimant. So, responding then to the appellant's case about section 42B, what this depends on is the possibility of isolating the opening words of subsection 42. Because if you read them as just a rent repayment order is an order requiring the landlord under a tenancy of housing in England to do something, well then it could be any landlord under a tenancy of housing. But the problem in my submission with that is that one immediately has to look further in the statute to find ways of actually limiting the landlord identified, because plainly a rent repayment order cannot be made against any landlord of any tenancy of housing. And so in my submission, the problems with my learned friend's approach are that one cannot simply construe these words out of context. That would offend against the principle that words in a statute are to be construed in context, that an act is to be construed as a whole. And that's a principle that derived from Benyon, section 21.1, which is in the bundle at page 581. And it's also clear from this court's decision in the King on behalf of the Project for the Registration of Children as British Citizens, which is quoted by both of the interveners, and that's in the Safer Renting's written submissions, for example, tab 1, page 10, paragraph 19.
That's Lord Hodge.
And that is Lord Hodge, my Lord, yes. I believe Lord Briggs sat with Lord Hodge, so maybe recall. So in my submission, the starting point is one cannot just read these words out of the context in which they are used. And my Lord, if you look to page 281 on section 52, the section which is headed Interpretation of Chapter, you'll recall that it says rent repayment order has the meaning given by section 40. In other words, the meaning given by section 40 as a whole. And that requires us to look further than just the opening words. Now, my lords, it's not disputed that those opening words must be read with section 41(1), which you'll recall provides that a tenant or local housing authority may apply to the first-tier tribunal for a rent repayment order against a person who has committed an offence to which this chapter applies. So in other words, that imposes immediately a limitation on the opening words of section 42. It's not just the landlord under any tenancy. The landlord must have committed an offence to which the chapter applies. And it's also not disputed that it has to be read, the opening words have to be read with section 41(3), which provides that a local housing authority may apply for a rent repayment order only if the offence relates to housing in the authority's area. So it's not disputed, I think, that these words, or that one has to look further in order to understand what the draftsman means when these words are used in context. But that context includes more immediately subsection 42B. And the deliberate choice to use the definite article before the reference to tenancy in subsection 42B can only establish a direct link back to the reference to a tenancy of housing in England in the opening words. And my lords, that is reinforced in my submission when section 40, subsection 2 is read with section 45, which is over on page 274. Now, this sets out the amount of a rent repayment order on an application by local housing authorities. And subsection 3 provides that the amount that the landlord may be required to repay in respect of a period must not exceed the amount of universal credit that the landlord received directly or indirectly in respect of rent under the tenancy for that period. So again, there is a direct link back made here to the opening words of section 40 subsection 2. The definite article used in 45(3) contemplates a tenancy which has already been identified. That tenancy, and indeed in order to identify the tenancy which has already been identified, one has to look back to section 42. My learned friend for the appellants paused on the inclusion in section 45, subsection 3 of the words directly or indirectly. Now, it's the respondent's case that those words are included to address the fact that universal credit might be paid to the occupier, who then passes it on essentially by way of rent to the immediate landlord. In that situation, the landlord has indirectly received payments of universal credit in respect of rent under the tenancy. And the word directly is included to include the factual situation where, under the regulations we've just considered, the state pays universal credit directly to the landlord. Now, the appellants try to get around this by submitting that it is possible for universal credit to be paid directly or indirectly to the immediate landlord of an occupier and then passed on to the superior landlord, who indirectly receives from their immediate tenant, but not the occupier, an amount of universal credit. In my submission, that interpretation cannot be right for a number of reasons. The first is that what is paid to the immediate landlord by the occupier is clearly an amount in respect of rent under the tenancy of the occupier. But what is paid from the immediate landlord...
Sorry, you're going to have to go a little more slowly. My note. So your first submission is what is paid by...
What is paid, my lord, to the immediate landlord. So if we take Lord Briggs's example, X is a superior landlord, grants a tenancy to Y. The intermediate landlord grants a tenancy to Z, who are the occupiers. So the amount which is paid by Z to Y under the bottom tenancy is an amount which is paid in respect of rent under that tenancy, the occupier's tenancy. But what is then paid by Y up to X, so from the immediate landlord up to the superior landlord, is a wholly separate payment of rent due pursuant to wholly separate contractual obligations in a totally different tenancy. And so, in my submission, it is an unnatural reading of the statute to talk about that being the indirect receipt of universal credit rather than just the direct receipt of the rent due under the head tenancy between X and Y.
And in any event, you would say it's a receipt-based liability rather than merely a quantification mechanism.
Yes, my lord. And the second point to make about this, the interpretation advanced by my learned friends next to me, is that it is unworkable in practice. If the ultimate tenant, so Z, pays, say, £150 per week to their immediate landlord, Y, under the lower tenancy, it is possible that, say, £100 of that amount might be paid by universal credit, and the other £50 paid out of the tenant's own pocket, properly speaking, as rent. Now, if the immediate landlord were to go on to pay to the superior landlord, so Y to X, a lesser sum of, say, £50, it would not be possible to work out, properly speaking, whether that superior landlord had indirectly received any universal credit or not. And indeed, it's possible to take that thought experiment a little further, because there could be, indeed there are, a situation where there are multiple tenants of the immediate landlord, some paying all of the rent themselves out of their own pocket, some paying it entirely out of universal credit, and some paying it out of a mix of the two. So one could immediately see that it would become enormously impractical, if not impossible, without employing some apportionment for which the statute doesn't provide, or resorting to the principles of tracing, to work out how the superior landlord could be said to have indirectly received any universal credit, and if so, how much. And indeed, my lords, that would mean that unless any universal credit had been paid directly to that superior landlord, the amount which, under the formula at section 45(3), that the superior landlord could be ordered to repay would be nil. And the third point to make about the appellant's interpretation of 45 subsection 3 is that it does not fit with subsection 42b, which we've just been looking at on page 269, which in my submission, and the Court of Appeal also found, clearly connotes a direct link between the landlord, who is the respondent to the rent repayment order application, and the tenancy in respect of which universal credit was paid in respect of rent. In other words, the direct landlord of the occupier. So, my lords, my submission is that the far more natural reading of section 45 subsection 3 is that the words received directly or indirectly are included just to allow for cases where the landlord receives a payment from a tenant which passes on payments of universal credit made to them in respect of rent under their tenancy, or where the universal credit is paid directly to the immediate landlord in respect of rent under the tenancy. And if there were any doubt about that interpretation, then in my submission, the principle against doubtful penalisation must be engaged. And I'll come on to that shortly. Just before I move on, there is another important point in my submission about section 42 subsection B, which is relevant to a question that one of my lords raised an argument. I can't remember whether it was Lord Burrows or Lord Briggs. The point was raised that on the appellant's case, it might be possible for any tenant anywhere in the chain to apply against any landlord for a rent repayment order. Now, on my case, section 42b does not allow that, because it anchors, essentially, the rent repayment order to the tenancy between the occupier who receives universal credit in respect of rent under that tenancy and their immediate landlord. So in other words, a rent repayment order is not something that can be made, if one reads section 42 in the way for which I contend, a rent repayment order is not something that can be made in respect of rent any further up the chain. And
conversely, would you accept that there may be circumstances where the superior landlord has committed the relevant offence?
I would.
The direct landlord has not, and then this would be an empty vessel for recovering?
I accept that, my lord, and my response, and I'll develop this more fully in due course, is that Parliament has made sure that in that situation there are many other ways in which its policy aims are furthered and upheld. But if we just take for a second that example or I think the example that was being explored with my learned friend in argument, suppose you have a situation where a superior landlord X grants this tenancy to a rent-to-rent company Y, which then grants tenancies to occupiers Z. The superior landlord then decides that it wants to sell the property, but it doesn't want to have to deal with terminating all of these tenancies, so it just goes in, changes the locks, and throws the occupiers out on the street. In that situation, the only party that would have committed the offence would be the superior landlord, Party X, under Section 1 of the Protection from Eviction Act of 1977. The immediate landlord wouldn't have committed any offence. But that would mean that the immediate landlord could apply for a rent repayment order, even though in its true nature that the offence has really been committed against the ultimate occupiers of the property. And that, in my submission, would be a rather bizarre outcome, because the offence
would be a bizarre outcome.
The offence would not, properly speaking, have been committed against the immediate landlord, and yet it would be in a position to apply for a rent repayment order, notwithstanding the fact that it was not, properly speaking, the victim of the offence. And the reason why my reading of Section 42B, and indeed the Court of Appeal's interpretation, deals with this problem, if I can put it like that, is that it makes sure that the rent repayment order is always liable to be made only in respect of the very bottom tenancy. I accept, of course, my Lord, that that creates issues in certain circumstances. We're all agreed that on the Court of Appeal's interpretation, there are some situations in which a rent repayment order cannot be made. But if I may, I'll come on to address that in the round when we're looking at the wider policy framework.
Can I just be clear about that submission? Your point about the interpretation of the Act is that rent repayment orders are only available to the occupying tenant and are not available to the immediate landlord for rent that the immediate landlord has paid to the superior landlord.
Yes, my Lord. Save that there's one qualification to that, which is, of course, local housing authorities would also be able to apply.
Yeah.
But the local housing authority can only apply for the return of universal credit. So, again, it's consistent with that, and it would be a slightly bizarre outcome.
So it's not that we're following privity of contract chains and only allowing rent repayment orders where there's privity of contract. You're actually imposing, or reading the Act as imposing, a further restriction that it's only the bottom privity of contract. Is that correct?
Yes, my Lord.
Yes.
And that's consistent with what I say is the reading of Section 42B, which is that the local housing authority can apply to recover universal credit which has been paid, and that will only have been paid to the immediate landlord of the tenancy right at the bottom of the chain.
And another case where it may be said to reveal a gap in the system is if the immediate landlord has no money, or if the immediate landlord is deliberately set up by the superior landlord for the purposes of avoiding precisely this machinery.
They could avoid, though, my Lord, only a rent repayment order, either being made against them or paying it.
Yes.
What they could not avoid is criminal liability.
I beg your pardon, by machinery I meant this machinery.
Yes. I accept that follows from the Court of Appeal's conclusions and from my interpretation. But we must, as I've emphasised at the outset, see this in context. So even in that situation, there will be criminal penalties which can be pursued and civil fines which can be imposed, including on directors of the corporate entity which has committed the offence, as I'll come on to show you in due course, my Lord. So I appreciate the objection or the concern. In my submission, there is an answer to it, or there are several answers to it, and I will come on to those in due course.
It's odd, isn't it? Because if that is a fundamental principle, it could so easily have been spelt out by requiring in Section 41(2)(a) that the tenant was let to him as his residence, or in some way for his occupation, or something that links the occupying tenant as the only relevant claimant apart from the housing authority.
Yes, my Lord. Though in my submission, when you read 41(2)(a) with 42B and 45(3), and as I'll come on to address you just a second, Section 44, throughout the chapter of the Act, we can see that what is contemplated is a rent repayment order being made in respect of the tenancy under which someone actually occupies the premises. And indeed, that is consistent with the purposes of Parliament in enacting the rent repayment order machinery in the 2004 Act, which I was referring to Lordship to in opening. It had a slightly curious origin to deal with this strange situation where tenants were withholding rent under an illegal contract. Those covenants were made enforceable, but the occupier was given a remedy.
I'm not familiar with all the details of the various offences which are listed in section 40, subsection 3, but would it be fair to say, or is it not fair to say, that those offences are all designed to protect the occupier of the, or occupiers of the premises?
Yes, my lord, it would. That's another good way of looking at it, yes. So for those reasons, my lord, what I say about section 42B is that the Court of Appeal was right. It connotes a direct landlord and tenant relationship between the occupier of the property and the landlord, and the tenancy that's contemplated is that tenancy in respect of which universal credit was paid in respect of rent. Now, if my lords will allow me to proceed on the basis that that is right, we now come on to look at section 42A, which is the provision which is actually engaged in this appeal. So that's back on section 269. Now, in my submission, again, the opening words and paragraph A all need to be construed in the context of subsection 42 in totality, and the rest of the chapter as a whole. Now, my lords, you'll see that the words under the tenancy do not appear in section 42A, as they do in 42B. And if they were there would be a direct link between the applicant, tenant, and landlord spelled out in the language. And what the Court of Appeal held was that those words didn't need to be spelled out because they were necessarily implicit. And in my submission, that is right for a number of reasons. The first is that section 42A alone does not actually identify any particular tenancy. It's just a rent repayment order is an order requiring the landlord under a tenancy of housing in England to repay an amount of rent paid by a tenant. So there are no limitations actually imposed by 42A. And it's not disputed again that this section has to be read in the light of section 43, which provides which sets out the definition of an offence to which this chapter applies, and also 41(2)A.
Sorry, it's limited by section 40, subsection 3.
Yes.
And also by...
and that's because, my lord, section 41, subsection 1 says that a tenant or local housing authority may apply for a rent repayment order against a person who has committed an offence to which this chapter applies. So there's the limitation. So it's 41(1) and 43 read together. There is a further limitation at 41(2)A. A tenant may apply for a rent repayment order only if the offence relates to housing that at the time of the offence was let to the tenant. So, in other words, my lords, that section 42A cannot be read in isolation, or it would enable a tenant to get a rent repayment order against anyone. For the sense in which the draftsman used this to be comprehended, one has to look at the wider context in which it was used.
And you've got your further point that under the same tenancy to the same tenant in occupation, that person in occupation may be receiving a benefit and also paying rent.
Yes. Yes, my lord, exactly. So in my submission, the opening words of section 42 in a subsection 42B case are qualified by the words in respect of rent under the tenancy. Now, in a 42A case, the same qualification has to be read into the words of section 42, the opening words. In other words, the landlord contemplated there must be the same. And that, in my submission, must be the case because, as my Lord Kitchener has just alluded to, it is possible, where an offence is committed, for a tenant to make an application against a landlord in respect of rent paid, and for a local authority to make an application against the same landlord in respect of universal credit, which has been paid. Now, the statutory language there, in such a case, doesn't allow for there to be a different landlord. It must be the same landlord under the same tenancy. And so, reading the opening words of subsection 2 in the light of subsection 2b, as my submission 1 must, one establishes that in a subsection 42a case, again, the tenancy in respect of which a rent repayment order can be made is, the respondent against whom a rent repayment order can be made is the respondent under the tenancy of housing in England in respect of which an amount of rent has been paid by a tenant. And, my lords, I can take that point further, and I don't think this is something which the Court of Appeal expressly considered, but that conclusion that the words under the tenancy are implicit in section 42a can also be gathered from section 43(3)a, which tells us that the amount of a rent repayment order under this section is to be determined in accordance with section 44, where the application is made by the tenant. Now, my lords, if you turn to page 273 and consider section 44, subsection 3, what it refers to is it says the amount that the landlord may be required to pay in respect of a period. Now, in my submission, the reference to the landlord is the reference to the landlord in respect of, well, the landlord against whom an RRO is made. But it goes on. So the amount of the amount that the landlord may be required to pay must not exceed A, the rent paid in respect of that period, less B, any relevant award of universal credit paid in respect of rent under the tenancy during that period. Now, again, the reference to under the tenancy does appear in section 44, subsection 3. Now, that contemplates, because of the use of the definite article, a tenancy which has already been identified. And in my submission, it refers back to the tenancy identified, or contemplated rather, but not identified in section 42 in the opening words. Because, my lords, when section 42a is read together with section 44(3), it has the following meaning. A rent repayment order is an order requiring the landlord under a tenancy of housing in England to repay an amount of rent paid by a tenant, which must not exceed the rent paid less any relevant award of universal credit paid in respect of rent under the tenancy.
May I ask you to repeat that, please?
I will, my lord. I appreciate that, Mr. Leach. So, what I'm doing is reading together section 42a.
One of the difficulties is that we've got them electronically, or some of us have got them electronically, and we don't have them all open at the same time.
I appreciate that, my lord. So, 42a, a rent repayment order requiring the landlord under a tenancy of housing in England to repay an amount of rent paid by a tenant. When you read that with 44(3), you get the following meaning. I'm sorry to keep repeating the opening words. A rent repayment order is an order requiring the landlord under a tenancy of housing in England to repay an amount of rent paid by a tenant which must not exceed...
If I'm to jot this down, I'm afraid you'll have to go a bit...
I'm sorry, my lord. So let me start again. The meaning one gets is the following. A rent repayment order is an order requiring the landlord under a tenancy of housing in England to repay an amount of rent paid by a tenant which must not exceed the rent paid less any relevant award of universal credit paid in respect of rent under the tenancy.
And you say that only makes sense if it's the tenancy we're talking about as between the occupier and the immediate landlord?
Quite so, my lord. And if your lordships would, as I have done, underline in their note of what I have just said, a tenancy of housing, and under the tenancy, it should, I hope, cause the emphasis for which I contend to leap from the page. Because what one gets when one reads those sections together is a version or a meaning of section 42A, which is the same as 42B. So in 42B, the words under the tenancy are expressly written in the statute. Under 42A, they are implied into the section when one reads it in the context of both 42B and 44.3.
This isn't a submission. I don't think that it didn't appear in the Court of Appeal's reasoning as such. But you're really extending what they said about 42B having effectively to be read with 42A by making the additional point that you also need to read 42A with 43.3.
Yes, my lord. Yes.
And in particular, because 44.3 is all about what tenants get.
Yes, my lord.
In other
yes.
words, it's about orders under 40 sub 2A.
Quite so. And in my submission, my lord, this is the...
So you can't hive off the local authority claim for the purposes of this analysis. Save only in the sense that it expressly contemplates that the tenant may simultaneously be paying rent and being in receipt of universal credit.
Yes, to be clear, I'm not trying to hive off the local authority claim. I say that the
No,
two...
no, you're not, but it might be
I see.
suggested that your opponent is.
Yes, it might be, my lord. Yes, and going back to what my Lord Briggs was saying in argument earlier, there's a question about where the quantification mechanism features. And in my submission, the quantification provisions are not to be found in section 42. They are to be found in sections 44, amount of order tenants, and section 45, amount of order local authorities. And both of those quantification sections use the same formula. They both use any relevant award of universal credit paid to any person in respect of rent under the tenancy. Not quite exact it's not exactly the same in 45.3, but it is the amount of universal credit that the landlord received, directly or indirectly, in respect of rent under the tenancy. So both of the quantification mechanisms contemplate in my submission the tenancy contemplated but not identified in the opening line of section 40, subsection 2. Now, my lords, there are some other pointers in the statutory language which the Court of Appeal accepted below, which lead to, or which point to that being the correct approach. The first of those is the wording of section 41.1, read with 43 and 41.2a. So, section 41.1 provides a tenant or local housing authority may apply to the first-tier tribunal for a rent repayment order against a person who has committed an offence to which this chapter applies. Now, the formula, offence to which this chapter applies, is a defined term. It is defined by section 40, subsection 3, which tells us that a reference to an offence to which this chapter applies is an offence of a description specified in the table that is committed by a landlord in relation to housing in England let by that landlord. Now, because the phrase offence to which this chapter applies is defined, in my submission
where do we get that?
It's section 40, subsection 3, my lord.
Right.
So, in my submission, wherever one reads in the statute, or whenever one reads in this chapter, rather, offence to which this chapter applies, one has to read in the formula, the definition which is spelled out in section 40, subsection 3. And then, my lords, one needs to look at section 41.2, which tells us that a tenant may apply for a rent repayment order only if the offence relates to housing that at the time of the offence was let to the tenant. So although the words by that landlord are not repeated in section 41.2a after let to the tenant, it is in my submission implicit that when one reads 41.1 and 41.2a together, that the draftsman is contemplating a direct relationship of landlord and tenant. In other words, property let by that landlord to that tenant.
I mean, in a way, that's an example of what is present throughout these sections, is that there's only ever references to a landlord and a tenant, and the natural reading of it might be that the tenant is the tenant of that landlord. I mean, that's really what you're getting out of that, isn't it?
Indeed, my lord, yes. And I'm just trying to draw attention to the statutory language which makes that point good in my submission. There are other pointers as well. Although I don't say that this is decisive, the use of the word repay, and the fact that it is the landlord which must do the act of repaying, is consistent with the need for a direct relationship of landlord and tenant. Tenant pays rent to landlord, landlord repays to tenant, is more consistent with the natural meaning of the word repay.
Well, I think the upper tribunal recognised that as a starting point.
It did, before departing from it. And it was a point that found rather more favour, perhaps, in the Court of Appeal. But I recall that the Deputy President and I had some in-depth exchanges about dictionary meanings of words. And I think on that point he bowled me out, I think it's fair to say. So the third point, or the third pointer on which I rely, is a section to which my learned friend has already taken you, which is section 1.3c of the Protection from Eviction Act, which is, for those using tabs, tab 10, it's page 285 of the bundle.
Sorry, can you give me that page?
Yes, my lord, 285.
That's 3 capital C.
Yes. So this is the addition by the Housing Act of 1988 to the 1977 Act. And as I say in my written case, the first of the offences, actually to use the word landlord, is the one which is introduced as section 1.3a of the 1977 Protection from Eviction Act. But what the draftsman did at the same time, in subsection 3c, was to extend the definition of landlord, and to say that in subsection 3a above, landlord, in relation to a residential occupier of any premises, means the person who, but for the residential occupier's right to remain in the occupation of the premises, or a restriction on the person's right to recover possession of the premises, would be entitled to occupation of the premises. So pausing there, that is the immediate landlord, and any superior landlord under whom the person is liable. Now, in my submission, the draftsman of the 2016 Act can be taken to have been aware of this expansive definition, because this is one of the offences which is actually referred to on the face of section 43, subsection 3 of the 2016 Act. And in my submission, the natural inference is that the draftsman has made a choice not to include a more expansive definition and to keep the meaning of landlord consistent with there being one landlord and one tenant. And the fourth pointer to the correction of the Court of Appeal's construction is in my submission section 44, which is on page 273. We've just been looking at. Now, this, as we've seen, requires the amount of a rent repayment order on an application by a tenant to relate to the rent paid and not the rent received. And that's significant because, as we've explored, the rent which is received by a superior landlord from their immediate tenant, the intermediate landlord, might be much less than what the occupier paid to their direct landlord, to the intermediate landlord. So to use the X, Y, Z, the amount that is received by X, the head landlord at the top of the chain, in rent may be considerably less than what Z, the occupiers, are paying to Y.
In this case, we know it was less.
And in this case, we know it was less, as is...
Perhaps not considerably less, but it was less.
And that is indeed commonly the case with rent-to-rent models. The idea is you grant a tenancy of your property, you get a guaranteed rent under that lease, but then you allow the company to let to occupiers and to make a profit by obtaining slightly more rent under the occupiers' leases. But in my submission, the reference to the amount of rent paid is again indicative of the fact that Parliament intended the rent repayment order to be made only against the immediate landlord of an occupier. And it may be interesting in that connection just to explore the contrast with the Housing Act 2004, where in fact a different formula was used and the reference was to the amount which was received.
Which section is it?
So if, my lords, you turn to section 74 of the Housing Act, which is on page 265.
70 subsection 4 or
Sorry, it's section 74.
at page
265.
Thank you.
I apologise, my lord, that is not the correct reference. It is in fact page 255.
Thank you.
So this is back in the Housing Act 2004. And subsections 3, 5 and 6 contain a limitation, the amount that can be ordered to be repaid by reference to the amount that was actually received. Now, were a similar formula, I suppose, to have been adopted in the 2016 Act, one could see that it might be more just or understandable for a rent repayment order to be available against a superior landlord who may not have received as much as the rent that was paid by the ultimate occupiers. But the reference is to the amount, or the reference, the amount of the rent repayment order has to be determined alone by how much was actually paid.
Yeah, I'm struggling with why that makes any difference.
I agree.
I mean, here you've got an appropriate person being identified. It makes no difference. On your submission, I wouldn't have thought whether it's pay or receive. It's the same.
My lord, I suppose it would be yes. Yeah.
I think your point wasn't it, that if you're to include the superior landlord in the new regime, then the more appropriate formula would be by reference to the amount received by the landlord, rather than the amount paid.
Yes.
Isn't that the point?
Because when one looks at the quantification formulae in the 2016 Act, there is nothing that provides the tribunal with a means of limiting the amount of the order that is made based on what a superior landlord has received.
Well, the things that the tribunal must take into account in 44.4 are non-exhaustive, aren't they? Because it's the tribunal must in particular take into account the amount paid in 3A is only a cap, must not exceed, so that the structure contemplates you can't give the tenant more than he's paid, but it doesn't seem obvious that the tribunal could not take into account the fact that, if it were proved, that the superior landlord had received a great deal less than the tenant paid.
I suppose that's the case, my lord. If you turn to look, though, at section 46, which is the amount of the order which is made after conviction, so where someone has actually been convicted of the offence, what that tells us is that in that situation, the tribunal must, or the amount is to be the maximum that the tribunal has power to order in accordance with section 44 or 45, disregarding subsection 4. So in other words, it has to be by reference to what is paid. That is only subject to the caveat at section 46, subsection 5, which says nothing in this section requires the payment of any amount that by reason of exceptional circumstances the tribunal considers it would be unreasonable to require the landlord to pay. So where a superior landlord has been convicted, the reasoning perhaps doesn't apply quite so neatly, because there it seems that the amount that must be ordered to be repaid is the amount that has been paid, and that again is consistent with the draftsman or with Parliament intending that there should be this direct relationship between occupier and immediate landlord based on what was paid under that tenancy. But I won't push the point any further, my lord. But my lord, what is important in my submission is to stand back from this. If the Court of Appeal accepted, and as I say, rightly accepted, that a local housing authority is constrained by the language of section 42b only to obtain an order against the immediate landlord to whom universal credit has been paid, it would make no sense if a tenant had a greater entitlement and a right to go after a superior landlord in a section 42a case, given that universal credit is paid out of public funds, and given that Parliament was concerned in enacting this chapter with the polluter pays principle, there is no discernible policy justification for tenants but not local authorities being able to go after superior landlords. My lords, if I can come on now to the fallback case. I'm not sure it's consistent with the cricketing analogy, but I'll use it anyway. Which is, I'm sorry, my lord? Long stop case. Which is the principle against doubtful penalisation. In other words, if there is any doubt about the provisions that we've been discussing, then that needs to be resolved in favour of the respondent in this case. It does not follow that just because Parliament, or as my learned friend submitted, just because Parliament did not reuse the language of appropriate person, which was used in the 2004 Act, or provide a definition of landlord in the 2016 Act, that its purpose was to make RROs in England available against all superior landlords. In other words, my submission is not a proper approach to the statute to find an absence of a definition, or an absence of an express definition. Of course, I say that one obtains the meaning of the words, of course, by looking at them in their context. But it does not follow from the absence of a definition, or the fact that the definition of appropriate person was not readopted, that Parliament intended some wider class of people to come within the scope of the RRO machinery. That would involve an interpretation of the statute which would be contrary to the principle against doubtful penalisation. Now, my lords, it's a no doubt familiar principle. It's referred to in the Court of Appeal. It is in the bundle, or the relevant sections from Bennion, which summarises are in the bundle behind tab 24, page 591. And it's expressed as section 26.4. It is a principle of legal policy that a person should not be penalised except under clear law. This principle forms part of the context against which legislation is enacted, and when interpreting legislation, a court should take it into account. I accept that the principle may be displaced in circumstances where the language of the statute makes it clear that it was not to apply. But I draw attention to what is said at the bottom of page 591 by the editors who quote what Mr. Justice Brett said in Dickinson and Fletcher, and then over on 592, those who contend that a penalty may be inflicted must show that the words of the Act distinctly enact that it shall be incurred under the present circumstances. They must fail if the words are merely equally capable of a construction that would and one that would not inflict the penalty. And then further down that page, my lords, under the heading Strength of Presumption, the writers say that the presumption against doubtful penalisation is capable of being outweighed by other interpretive factors. And they quote Mr. Justice Sales, as he then was, in Bogdanic and Secretary of State for the Home Department, which makes clear that the principle is not absolute. But then underneath the quotation, they go on to say the weight to be given to the presumption will necessarily depend upon the circumstances of the particular case. One factor that is likely to influence the weight given to the presumption is the severity of the detriment. If the detriment is minor, the presumption may be expected to carry little weight. If the detriment is severe, the principle will be correspondingly powerful. Now, in my submission, there is nothing in the words of the legislation here which is clear enough to displace the operation of this presumption when one construes this statute.
Are you saying we never get to the presumption?
I say, of course, my lord, yes, that one never gets to the presumption, but if there is ambiguity, the backstop is engaged. But that is
it engaged only where there are two equally plausible meanings? The citation you quoted, was it from Brett?
It was Mr. Justice Brett and Dickinson and Fletcher, yes.
I think it talked about two equally, get the exact words.
I'm not sure, my lords, that I would say that they have to be equally capable of being valid constructions. If, in my submission, there is
a sort of a genuine ambiguity.
Yes, a genuine ambiguity is a good way of putting it.
It must fail if the words are merely equally capable of a construction that would,
yes,
one that would not.
Yes, so perhaps that is a different test that Mr. Justice Brett is expressing.
Your point is that if a penalty is to be imposed, clear words are required.
Indeed, my lord, yes. And that is especially so given that the detriment here may be very great. For instance, well, we know that the limitation on civil penalties, for instance, I think is £30,000 under Section 249A of the Act. A rent repayment order could be made against a landlord for a much greater amount of money than the maximum civil penalty that could be imposed. So that's indicative of this being a weighty detriment. Were it the case that a superior landlord were brought within the scope of the RRO machinery, they might, of course, be ordered to repay to a tenant an amount greater than that which they have actually been paid by their own immediate tenant. And that's something which weighed heavily, I think, with the Court of Appeal. And of course, my lord, it would have been simple and straightforward for Parliament to have included a wider definition of landlord, so that it did include superior landlord, as it did for Section 1(3)A of the Protection from Eviction Act 1977. And to pick up on a question that was put to me just before we broke for lunch, what is the policy justification for excluding agents from the RRO machinery? Well, my lords, it may well be that policy arguments, when weighed up, weigh in favour of a detriment being imposed on someone, but that does not necessarily correspond with what Parliament's intentional purpose was in the enactment that it has passed. So, for instance, well, I accept that policy factors may point towards rogue property managers being brought within the scope of the RRO regime, but clearly Parliament has not done so. And as Lord Briggs observed before lunch, if every penal statute is construed so as to give effect to the stated or even the presumed policy aims of the legislature, the principle against doubtful penalisation would need to be jettisoned. My submission, it shouldn't be. My lords, I now want to come on to the wider context of the Housing Act 2004. My learned friend did this in some detail, so I think I can cover the ground fairly quickly. It's common ground that the definition of appropriate person allows only for a direct relationship between the person who, the occupier who pays and the landlord who receives it. There is a helpful discussion of the policy background underlying the 2004 Act, which it's behind tab 19 of the bundle. It's page 446. Now, this is the decision. It's 446.
I'm so sorry, I misheard you.
This is an upper tribunal decision from 2012. It's a decision of the then President George Bartlett QC in Parker and Waller. And what he does on the preceding page, which I think was had the black line struck down it for the Court of Appeal, he finds that the purpose or the meaning of the local authority provisions in the 2004 Act are clear. He finds that there's some doubt about the meaning of the occupier application, so he resorts to the principle in Pepper and Hart and analyses some passages from Hansard. And having done that, at paragraph 26 on page 446, he says it can be concluded from this statement that the occupier RRO provisions have a number of purposes to enable a penalty in the form of a civil sanction to be imposed in addition to the fine payable for the criminal offence of operating an unlicensed HMO, to help prevent a landlord from profiting from renting properties illegally and to resolve the problems arising from the withholding of rent by tenants on the basis of illegality. And so that sheds a good light on the interesting origin story of rent repayment orders in this context of arguments about illegality. But, my lords, what you see from this is that the context very much is one of a direct landlord and tenant relationship. And if we now turn to section 73 of the 2004 Act, which is at page 251. My lord. This is section 73 as it stands today. So it's been amended by the Housing and Planning Act of 2016. Now, the subsection 3 is the section which deals with the issue about illegality. It's essentially a saving provisions in rent covenants and other covenants in tenancies of unlicensed HMOs. Then subsection 4 is very interesting because it provides, and this is in the context of the offence of being a person having control of or managing an unlicensed HMO. In this context, it provides that amounts paid in respect of rent or other periodical payments payable in connection with such a tenancy or licence may be recovered in accordance with subsection 5 and section 4 in the case of an HMO in Wales, or in accordance with chapter 4 of part 2 of the Housing Act 2016 in the case of an HMO in England. Now, what is significant is that, this is common ground, in Wales, a rent repayment order can be obtained under the 2004 Act only against the immediate landlord of the occupier. Given that the two different machinery are referred to in the same section of section 73, subsection 4, it would be extraordinary, in my submission, if Parliament had essentially by sleight of hand in enacting the 2016 Act made rent repayment orders available against a whole different class of respondents in housing licensing cases in England. And that, in my submission, is another pointer towards a direct landlord and tenant relationship being required in the 2016 Act. My lords, I want now to come on to the background material that we've had a look at, which we're all agreed is admissible, but of course it must play a secondary role to the words themselves. And a helpful reminder of the approach which this court takes was set out by Lord Hodge in the in this court's decision of last year in the project for registration of British children as British citizens case. My Lords, if I can just take you to that as a reminder, it's behind, well, it's quoted in the Safer Renting's written submissions behind tab 1 of the interveners bundle.
So it's page?
And sorry, my Lord, it's at page 11. In fact, the quotation starts on page 10 under paragraph 19.
It's the supplementary bundle, is it?
Yes, so the supplementary bundle, the interveners bundle, page 10.
Paragraph 19.
Yes.
Yeah.
Sorry, bear with me.
And
I'm sorry, you have to bear with me a moment. Carry on.
So what Lord Hodge said, just starting halfway down that paragraph, it's quoted, words and passages in a statute derive their meaning from their context. A phrase or passage must be read in the context of the section as a whole and in the wider context of a relevant group of sections. Other provisions in a statute and the statute as a whole may provide the relevant context. They are the words which Parliament has chosen to enact as an expression of the purpose of the legislation and are therefore the primary source by which meaning is ascertained. There is an important constitutional reason for having regard primarily to the statutory context. As Lord Nichols explained in the Spath Home case, citizens, with the assistance of their advisers, are intended to be able to understand parliamentary enactments so that they can regulate their conduct accordingly. They should be able to rely upon what they read in an Act of Parliament. And then Lord Hodge went on at paragraph 30 to say, external aids to interpretation therefore must play a secondary role. Explanatory notes prepared under the authority of Parliament may cast light on the meaning of particular statutory provisions. Other sources, such as the Law Commission reports, reports of Royal Commissions and advisory committees, and government white papers, may disclose the background to a statute and assist the court to identify not only the mischief which it addresses, but also the purpose of the legislation, thereby assisting a purposive interpretation of a particular statutory provision. The context disclosed by such materials is relevant to assist the court to ascertain the meaning of the statute, whether or not there is ambiguity and uncertainty, and indeed may reveal ambiguity or uncertainty. And then skipping on to the end, to the next sentence, but none of these external aids displace the meanings conveyed by the words of the statute that, after consideration of that context, are clear and unambiguous and which do not produce absurdity. And that is all I need to read. That is the approach which in my submission should be adopted to the background materials. But in my submission, nothing in those background materials, nothing that your lordships was shown earlier, points to a need to give the words of the statute anything other than their natural ordinary meaning, that being the meaning which the Court of Appeal gave them. And my Lords, you were shown the technical discussion paper of August 2015, which is at page 599 of the bundle.
Page
599, my Lord. So this is before the Housing and Planning Act was introduced to Parliament. And it's clear from reading this that the government understood that rent repayment orders could at that point only be obtained against immediate landlords. There is no reference anywhere in this document to superior landlords. What it shows, my submission, is that the government was simply contemplating extending the existing rent repayment order machinery to new offences, or making it available where new offences have been committed, but by the same respondent, i.e. the direct landlord. And my Lords, if you turn to page 610 of that discussion paper, there are a number of passages which bear that out. So under the heading Rent Repayment Orders, that paragraph, starting with the third sentence, the government says, under the current system, a local authority or a tenant can apply to the first-tier tribunal for a RRO where a landlord has committed the offence of not having a licence for a licensable property. Now that refers to the current system. What we then see in the next paragraph, rent repayment orders are effective because they make it unprofitable for a landlord to dodge their responsibilities. We are considering extending them to cover other scenarios. Now that again contemplates the extension of the existing regime to new offences. And just pausing there, in fact, my lords, because it occurs to me that or some light might be shone by this paragraph on the question that was asked to me before lunch: what is the policy justification for not extending rent repayment orders to agents? And it seems to me that that paragraph may shed some light on Parliament's thinking. They make it unprofitable for a landlord to dodge their responsibilities. RROs, of course, emerged in the case of housing licensing, so that might explain why it was that, given that the licensing responsibilities would have fallen presumably on the person, the subject of the RRO. That may just shed some light on why Parliament's thinking about RROs is limited to landlords. But I accept it doesn't illuminate the question entirely, because there are, of course, other offences which can be committed by others equally. But anyway, my lords, moving on then to the paragraph underneath the bullet points. No reputable landlord will behave in this way, and it is unacceptable that a small minority of landlords knowingly rent out substandard and potentially dangerous accommodation, particularly where the rent is being paid either partially or in full from housing benefit or universal credit. Again, the new scenarios which are contemplated here also contemplate a direct relationship of landlord and tenant, and that's clear from that paragraph. And the paragraph underneath that: an illegal eviction occurs where a landlord forces a tenant to leave their home without following the correct legal procedure, which generally includes serving a possession notice and obtaining a court order. Now, interestingly, although the offences under the Protection from Eviction Act could be committed by anyone, the correct legal procedure, of course, is that which is operated by the immediate landlord, who has the entitlement to serve a notice of seeking possession. So again...
Yes, but evading the legal procedure might be done by anybody.
Yes, save that a superior...
This isn't about complying with it, it's about not complying with it.
Yes, my lord, of course I accept that, but a superior landlord would not be able to operate this procedure because they would not be able to serve a notice on the occupier. And then just the last sentence of that page. As noted above, however, fines have to be set at a level that takes account of the landlord's means, so may not reflect how much rental income the landlord has received from the tenant. It's a very clear contemplation there of a direct landlord and tenant link. Over on page 611, the last sentence of the paragraph at the top of the page: where rent has been paid through housing benefit, the rent would be repaid to the local authority. Again, that contemplates a relationship there between the local authority and the person, the direct landlord, to whom housing benefit or universal credit was paid. And then the last sentence to draw attention to is the sentence that starts: the current rent repayment order system requires a local authority to apply for an order after satisfying a first-tier tribunal that the landlord has rented out a licensable property without having obtained a licence. Now, of course, that's the landlord, and so that's local authority against the direct landlord of the tenant. For tenants, they can only apply for an order after a landlord has been convicted of doing so. So that identifies the difficulty for tenants of the need for a local housing authority first to have obtained a rent repayment order, and contemplates simplifying the procedure for tenants, but again with the same landlord respondent contemplated. So in my submission, all of that shows that this is not something which has been contemplated by the government. All of this is consistent with a government taking the existing rent repayment machinery under the 2004 Act and simply extending it to new offences, but not to a new class of respondents.
I see that if you look at the list of questions, because this is a consultation paper, on the same page there is no question directed at who should be the subject of a rent repayment order. It's not asked, should we extend the category of landlord to include superior landlords?
It's quite similar. There is no consultation on that question, as those who act for the National Residential Landlords Association have pointed out. What is interesting is that if we turn over to tab 27, starts at page 617, we see the government's response following this technical discussion. And this is November 2015, so just after the bill has been introduced to Parliament.
Sorry, the page again.
Page 617. Again, there is nothing in the government's response to suggest that they are even thinking about extending the rent repayment order to a new class of respondents. At 629, under the heading Extending Rent Repayment Orders, all that the government says is rent repayment orders are currently available where a landlord, i.e. the direct landlord, has failed to obtain a licence for a licensable property. The government has decided to extend rent repayment orders. In future, they will also be available where, and then they just list some of the offences.
Sorry, again, the page. Can you give me the page?
I'm sorry, my lord, yes, page 629.
629.
At the foot of the page.
Thanks.
But an interesting observation, striking observation perhaps, my lords, if you look at page 631, the very end of this government response, under the heading Impact Assessment, they say the measures outlined above have been assessed in an impact assessment which will be made available shortly. Now that impact assessment helpfully has been included in the interveners bundle behind tab 7, or some extracts of it anyway, and that's at page 75 of the interveners bundle. And what does not appear to have been impact assessed is the extension of the rent repayment order regime to a new class of landlord. The explanatory notes which accompanied the introduction to the bill, my lords, they are also in the bundle, the interveners bundle at 78. The relevant paragraph, which I won't refer you to, it's for your notes, it's pages 79 and 80. It's referred to in the National Residential Landlord Association submissions. Again, suggests that Parliament was simply extending the existing model to new offences. And, my lords, I commend to you the analysis of the background material which is set out in the submissions for the NRLA. It's tab 3 of the interveners volume, paragraphs 17 to 29.
Sorry, page.
So that is, it's paragraphs 17 to 29, my lord, and it ends at page 36, I can tell you, but I realise that's not the most helpful reference.
It ends at 36.
It ends at 36, and paragraph 17 appears on page 31.
And what is that?
So those are the submissions, the written submissions by Counsel Robert Brown and Rosamond Baker, instructed on behalf of the NRLA.
Yeah. Thank you.
And, my lords, I adopt their submission at paragraph 29, which is on page 36 of the bundle, where they say, at no point during the legislative process did the government say that it was intending to add to the class of persons against whom an RRO could be made. A consultation was not carried out on such issue, and responses were not recorded on this issue. Parliament does not seem to have considered such issue, and the explanatory notes for the legislation do not address such issue. And, my lords, as they point out, extending the scope of the detrimental rent repayment order machinery to include superior landlords would be a very significant intervention. And as well as seeing that spelled out in clear language in the 2016 Act, one would expect it to have been properly considered, consulted upon, and impact assessed in advance. So, in my submission, concluding what we say about this, far from justifying the appellant's interpretation of the statute, in my submission, the background materials fully support the conclusion of the Court of Appeal.
Bearing in mind the constraints on looking at travaux preparatoire and paper.
I'm sorry, my lord.
Bearing in mind the constraints on looking at these sort of materials in public art, is there any track record for just building castles on silence?
For building castles
on silence. I mean, you could be said to be building a castle in silence by saying, well, there's nothing of any of this in any of the travaux preparatoire, therefore it isn't included.
Yes. I suppose I am saying that, my lord. My starting point, and I suppose in one sense the ending point, is the words of the statute, where it is also included.
Yes.
But to the extent that these materials are admissible, they shed light on the policy, the mischief that Parliament was trying to address, and in my submission, the idea that superior landlords can commit offences was not within that contemplation. And so to that extent, the materials are admissible and helpful.
Okay.
But I stress that I'm not, well, I suppose actually, rowing back on what I just said about building a castle on silence, I'm not building a castle on silence. I am simply pointing to the silence. But the castle is to be found in the words of the statute itself.
Oh, sure.
And the explanatory notes don't really take us much further, I suppose.
No, well, they don't. Since you've raised it.
Well, I didn't want to take you off your thing. I mean, we can read these in our own time, but.
Yes. So, my Lord, I can do it very briefly. They're very short on this point. If you take up the interveners bundle and turn to page 79, here, Chapter 4 is addressed, although at this point it was Clause 32 of the bill. It's just introductory. You skim through it. The critical bit of my submission is, in respect of breach...
Page 79 of the bundle.
Sorry, 79.
Yeah.
Clause.
Chapter 4, it's headed.
It's paragraph 110 at the bottom of the page.
Yeah.
Confusingly, it was then Clause 32 of the bill, but it became Section 40. Just as this clause lists the offences concerned, and then says, in respect of breach of licensing requirements, the chapter consolidates existing provisions with certain modifications. In my submission, introducing a new class of respondent could not reasonably be said to be a modification. The modification, I think, is the abandonment of the appropriate person formula and the replacement of this landlord and tenant formula. And all it says is the chapter newly extends the power, i.e. the power under the 2004 Act, to the other cases. And that is all that is said.
Thank you.
So, my Lord, what I'll do now is, 20 minutes, come on to the wider background and some of the policy considerations. It's common ground, I think, that Parliament's purpose in enacting the 2016 Act was really threefold. First purpose was deterring and punishing landlords who flout their responsibilities to their tenants. Secondly, driving rogue landlords out of the sector. And thirdly, driving up housing standards across the sector. And critically, the way in which Parliament did that was not limited to the rent repayment order Part 2 of the 2016 Act. Part 2 also introduced banning orders, which enable local housing authorities to prevent rogue landlords or rogue property agents from operating in the sector. And a banning order can be made in respect of a very wide variety of offences, much wider than engaged by Chapter 4. And secondly, it introduced the database of rogue landlords to enable housing authorities to keep tabs on landlords with a bad track record who might be operating in their area so that they can focus their resources on policing regulations in their area and driving up standards. And thirdly, it introduced this new Section 249A into the Housing Act, which is very important because that allows a local housing authority, in lieu of prosecution, instead of taking someone to the magistrate's court, to impose upon them a civil fine and allowing them to keep that civil penalty to use themselves for housing purposes. And that's what Parliament had in mind when it talked about the polluter pays principle. Now, as we've seen, my Lords, there are numerous occasions on which an offence referred to in Chapter 4 will be committed by someone who is not a landlord, but who will still make a profit from the letting of housing. Parliament, we know, did not make a rent repayment order available in such a case, relying instead on the wider regulatory scheme of the 2016 and the 2004 Act to further its purposes. And my Lords, by the same reasoning, even if a rent repayment order cannot be made against a superior landlord, the wider scheme of enforcement across the Housing Act 2004 and the Housing and Planning Act 2016 ensures that Parliament's purposes are furthered and upheld. So let me just walk this through. First of all, a superior landlord will still be deterred from committing one of the RRO offences. They will be liable to criminal penalties, which are fines in every case, and imprisonment in some cases. And I think for one of the offences in the Protection from Eviction Act, if a landlord is convicted on indictment, I think the fine is, or the sentence can be up to 2 years of imprisonment. So these are not insignificant criminal penalties. And for your reference, I don't think there is time to go through them all, but the sections that I rely on are Section 6 of the Criminal Law Act, it's at page 283, Sections 1, subsections 2, 3, and 3A of the Protection from Eviction Act, that's at page 285. Section 30 of the 2004 Act, that's at page 316. It's a breaching and improvement notice. Section 32, which is at page 319, that's breaching a prohibition order. Section 72(1), that's the HMO licensing offence, that's at page 249. Section 95(1), which is having control of or managing an unlicensed house, that's at 329. And finally, Section 21 of the 2016 Act at 364, which is the offence of breaching a banning order. Now, in the case of particular offences, a local housing authority can, instead of prosecution, impose a civil penalty. We've looked at Section 249A of the 2004 Act. It's at page 264. That is in respect of sections 30. The offences in Section 30, 72, and 95 of the 2004 Act.
Sorry, 70.
So it's 30, 72, and 95 of the 2004 Act. And Section 21 of the 2016 Act. Although, to be clear, my lords, in fact, in the 2016 Act, it's not Section 249A, which gives the right to impose the penalty. It's, in fact, Section 23 of that Act, which mirrors Section 249A in the 2004 Act. And that is at page 366 of the bundle. And that imposes or creates the right to impose a civil penalty in the case of breaching the banning order, which is an offence introduced by the 2016 Act. Now, my lords, where the superior landlord is a company, but it can be shown that the offence was committed with the connivance of or due to the omission of a director, or in some cases a member even of that company, in some cases someone just purporting to act as a director of the company, that human agent is exposed to the same criminal sanctions and also to a civil penalty where one is available. And that comes from Protection from Eviction Act 1977, Section 1, subsection 6, which we looked at briefly earlier.
1.
Subsection 6, my lord, page 286 of the bundle. For all the Housing Act offences, it's Section 251. That's at page 266 of the bundle. And for the 2016 Act, the right to go after a human agent is Section 22 on page 365.
Sorry, Section 22.
On page 365.
Thank you.
So what one sees is that even if no RRO is available against a superior landlord, the discipline and punish element of Parliament's purpose is furthered by the criminal penalties and the civil penalties. Now, secondly, as to driving rogue landlords out of the sector, a banning order can now be made against a superior landlord who is convicted of a much wider range of criminal offences than those engaging the rent repayment order machinery. And my lords, if we can just look quickly at, Section 16, I think my learned friend showed you, that's at page 359. But what it's
15, did you say?
So that's Section 16 of the 2016 Act, yes, which introduces the right to make a banning order. It's the first-tier tribunal that makes that on the application of a local housing authority. What is interesting to look at is the range of offences in respect of which a banning order can be made. So, my lords, if you turn to page 421 of the bundle, you will find the Housing and Planning Act 2016 banning order offences regulations. And if you turn on to page 422 and 422A, you will see a panoply of various criminal offences under numerous acts, not just relating to housing. Though,
does it include all the offences covered by Section 40?
Yes, my lord, it does, and more. So if you look on page 422, under the Housing Act 2004 at item 3.
Sorry, reference again, please.
422, my lord.
Yes.
Yes.
Section.
Item 3, which sets out the Housing Act 2004 offences,
Yes.
you will see that a banning order offence includes an offence under sections 72(1), 2 and 3, whereas you'll recall that a rent repayment order is available only in the case of a 72(1) offence. And in respect of section 95, a banning order can be made where both offences are committed, whereas a rent repayment order is available only in the case of a section 95(1) offence. Now, interestingly, my lords, there are 3 other offences introduced in the Housing Act 2004 which are banning order offences in respect of which no rent repayment order can be made. Those are 1397, contravention of an overcrowding notice, 2343, failure to comply with the management regulations in respect of houses of multiple occupation, section 2381, which is the provision of false or misleading information when a local authority asks you for information. Now, this schedule has to be read with Regulation 3, which, so for instance, for items 7 to 14, imposes certain limitations. So it's a banning order offence if some of those conditions are made out. But the point to make is that a banning order is available in the case of a very wide range of offences, far wider than rent repayment order under Chapter 4. So also in relation to driving rogue landlords out of the sector, my lord, landlords can also be added to the database of rogue landlords where they either breach a banning order or commit the banning order offences, so that local housing authorities know essentially where to concentrate their investigatory and enforcement energies in their patch. And the relevant sections, lords, are section 28 of the 2016 Act, which is at page 372. And that provides that a local authority must make an entry of a person's name in the database of rogue landlord where a banning order is made against them. I'm sorry, my lord, that section 29 does that. There is then a power to make an entry where a person is convicted of a banning order offence or 2 financial penalties are imposed on a person in respect of banning order offences, and that is section 30 of the 2016 Act, which is page 374. So that deals with the policy aim or the purpose of driving rogue landlords out of the sector. Then thirdly, as to driving up standards across the private rented sector, the Housing Act of 2004 confers on local authorities very wide-ranging powers to improve housing conditions by serving improvement notices and prohibition orders, and also hazard awareness notices. And the relevant provisions are section 11 of the 2004 Act on page 310. That imposes a duty in some cases to serve an improvement notice. And an improvement notice is a notice requiring a landlord to carry out remedial action or remedial works. Section 12 introduces a power to serve an improvement notice. That's at page 312. Section 20 imposes a duty to serve a prohibition order, which is an order which prevents a property from being let out or used in a particular way. That's at page 312. And Section 21 of the 2004 Act then introduces a power to serve a prohibition order, and that's at page 315. And, of course, when those notices are not complied with, or when a prohibition order is breached, not only is a criminal offence committed by the person who does that, who can be any person, not just a landlord or a superior landlord, but for our purposes, if a superior landlord were to breach a notice, not only would they commit an offence, but also the local authority then has considerable powers of entry to their property to carry out the remedial work specified in the notice. Those powers are referred to in section 31, or they're introduced in section 31 on page 318, and they're set out in schedule 3 to the Act, and we've put some paragraphs of schedule 3 in the bundle starting at page 351. And importantly, where a local authority does that, they can recover their costs of doing so. And also, my lords, a local housing authority can apply to the magistrates' court for an order permitting them or permitting to be done on premises anything necessary or expedient where an occupier of premises is preventing them from taking that action, and a person who fails to comply with such a notice themselves commits an offence. That's section 35, page 322. A person also commits an offence if they obstruct a person exercising a power of entry. That's section 241 on page 243. And so having completed that review of that exploration of the wider regulatory regime, my lords, what I submit is that in a case where a superior landlord commits one of the relevant housing offences, even if no rent repayment order can be made against them, the wider system of enforcement and regulation, policing, punishing, deterring, and driving up standards remains wholly watertight.
Could you get a Proceeds of Crime Act confiscation order as well?
My lord, I suppose you could. If someone were, if you were letting a property, if you were a person having control of or managing an HMO which required a licence, that is a criminal offence. You have received or gained a profit from that, so I suppose a POCA order could be made, yes. So just to try and draw this exploration then to a close, well, as I point out in my written case, Parliament clearly intended Chapter 4, the rent repayment order chapter, to be more limited in scope than Chapters 2 and 3. What it does is allow the profit to be removed from the landlord who directly lets property to occupiers but who commits one of the offences. The three mechanisms in Chapters 2 to 4 were clearly intended to work alongside each other, but to play different roles, applying to different scenarios and being available against different people in respect of different offences. So the rent repayment order, we can see, is, and always was, just one cog in a much larger enforcement regime. And just because in theory might be consistent with Parliament's presumed policy aims for a rent repayment order to be made against a superior landlord who has committed an offence, that does not mean that the statute must be read to achieve that result.
Well, I think you're coming towards the limit of your time.
My lord, then just if I can just make some very brief points about some of what is said in the submissions of safer renting. I'll be brief, and I will commend to your lordships the analysis of the problems highlighted by safer renting in the submissions of the National Residential Landlords Association. But just one important point to note is that the rent repayment order regime its purpose is not to compensate tenants. That's been repeatedly stressed by the upper tribunal, as it was by the Deputy President below in paragraph 64 at page 109 of the bundle. And that, my lords, must be right, because a tenant occupying property in respect of which a landlord commits an offence but who depends entirely on universal credit cannot make a claim for a rent repayment order because they have not paid any rent. And looking at the problems that are identified, as the National Residential Landlords Association...
Sorry, I don't follow that point. If you're trying to... If I just playing devil's advocate, if I wanted to say it's all about making sure that a tenant doesn't lose out, i.e. compensated for the payment they've made, why, if they've not suffered any loss, then obviously they don't get it.
Because, my lord, they would, I suppose the reason they would have suffered loss by virtue of living in housing in respect of which an offence has been made. So the loss is not the payment of rent. The purpose is to compensate tenants not for having paid rent, which they were going to have to do anyway. The point is that the purpose of ROAs is not to compensate them for loss which they have suffered.
Well, I mean, for example, a deeper point sure is a house may be unlicensed, but a perfectly delightful property to live in.
Indeed, my lord.
I think that's a point made
by Martin Roger QC below, yes.
So it's a remedy to get back money paid.
Yes, when I was thinking, my lord, earlier over lunch about your question about whether this is the whether the restitutionary analysis applies. And it seems to me that you can analyse rent repayment orders in that way, but that's not the only analysis, because there is, of course, an element of penalty combined, and we know that because conduct has to be taken into account. There are all sorts of factors. But interestingly, that it goes beyond that. There is also this polluter pays element. If universal credit is paid by central government, but the local housing authority recovers it in a rent repayment order, they get to keep it. So they have an incentive almost to go for rent repayment orders, and that gets them essentially a windfall.
Well, Mr. Morris, we've given you a generous time.
You have, my lord.
In addition to that allowed. I think we need to close now. So.
I'm grateful, my lord. Well, I was about to close it anyway. If I may just draw attention to two final bits of the statute for contemplation. The first is the... Oops, sorry. First, my lord, is the Section 48, which imposes a duty upon local housing authorities to consider applying for rent repayment orders where they know that a conviction has been, someone's been convicted. And the second is Section 278, page 278, Section 49, which provides that a local housing authority in England may help a tenant to apply for a rent repayment order. So that's the objections that are raised about people in the first tier tribunal being litigants in person, the first tier tribunal having to deal with complicated situations. Of course, the first tier tribunal is a specialist tribunal which is perfectly competent to deal with that. And the statute provides that tenants can have assistance from local housing authorities and indeed organisations like Justice for Tenants, which represented the...
And there is limited cost-shifting risk, isn't there, in the FTT?
There is. It's a cost-neutral tribunal, my lord, as is the upper tribunal.
Yeah.
Unless I can assist further, then those are my submissions.
Thank you, Mr. Morris. Any questions? Thank you, Mr. Morris. We're grateful. Mr. Fitzpatrick.
Thank you, my lord. In terms of the policy considerations, I referred to the submissions from Safer Renting and invite the court to consider in the main bundle at 156 in support of the case in the Court of Appeal. We've got their policy submissions starting at paragraph 6, and they go right back to the 2004 Act and the development of the policy. And I won't go through it in detail, but one starts off with consideration and review in relation to what's termed at paragraph 9 on page 157, the good-bad landlord divide. And there were consultations in relation to rent repayment orders and whether or not they would be extended to cover situations, I'm looking at paragraph 11 and 157, of illegal eviction and landlord found guilty of a criminal offence. In terms of what's been said, it's been said that effectively there was a change in the mechanism and an additional number of offences brought in from the 2004 Act. That's simply not the case. There was offences, a number of which will primarily relate to rogue superior landlords, introduced improvement order, breach of improvement order, prohibition, licensing offences, and all under the banner of rogue landlord as identified in the pre-legislative material, but also in the Act itself under Section 13. So, and it goes back to the points we made at the start. The policy direction is one that includes all rogue landlords, and that's invested in the Act, and that's why we say that in terms of construction of Chapter 4, that's what we're looking at. And if you're going to exclude liability in relation to the limit it very much to the only to the direct landlord, one would expect that to be provided for explicitly, as it was under Section 73. Another small point in relation to Section 73 itself is that my learned friend said that that was introduced to deal with tenants who weren't paying their rent. because their landlord was in breach of the licensing requirements. I mean, that's not a position that we on this recognise. It's referred to in the judgment in Parker as one of the reasons for rent repayment orders, but it was, in terms of it, then the other reason was to provide a means of penalising the landlord for not meeting the licensing requirements. It was not the basis of the statutory provision. I don't think there's any material before the court to say otherwise. So that's in terms of the policy considerations, and we say on our interpretation that's extremely important to look at the policy as it's directed and it's targeted to drive rogue landlords out of the market, and all the references to not allowing them to make a profit. And in my submission, that doesn't sit with the way my learned friends categorise the situation as not changing the status quo with the introduction of these additional offences insofar as rent repayment orders, not least because the mechanism, there is no limitation set. The limitation is with reference to a landlord, and that's under section 13, both in relation to banning orders and in relation to rent repayment orders. And we say that's significant. There was some discussion about what was meant by repay under section 40. And just to go to page 269, in my submission, if one looks at it from the perspective of the tenant, under section 40, subsection 2, focusing in on the tenant, a rent repayment order is an order requiring the landlord under a tenancy. It sets out what they're required to do. They're to repay amount of rent paid by a tenant. So that's exactly what's happening. The tenant has paid rent, and the rent's been repaid to the tenant. It's also dealt with in the judgment 102 of the upper tribunal. Sorry, 102, paragraph 30. And the point made there by the Deputy President is that the essence of repayment is that a sum is paid back to the person who originally made the payment. I do not regard this as indispensable that the person making the repayment should be the same person as received the original payment, or that only two parties should be involved, although both may often be the case. I mean, in fact, in relation to the statutory language, it's argued that there's a distinction under 2B because it said the local authority to pay a local authority rather than repay, because the local authority didn't actually the local authority didn't pay the rent or the amount of universal credit in the first place. I mean, it's a small point, but under section 45, subsection 3, in relation to local authorities, one can see that they use the reference there in assessing the amount is to repay rather than pay, which in a technical construction doesn't really make much sense.
So did you say 45.3?
My lord, yes.
Oh, yes.
So
That's on page.
it's on
Sorry, 274.
274.
Thank you.
The amount the landlord may be required to repay in respect of a period must not exceed the amount of universal credit the landlord received directly or indirectly in respect of rent or tenancy for that period. And your point is in relation to those directly or indirectly, as I understand it.
I mean, it's a small point, but it seems to be, yes, in terms of legislative choice, it's interchangeable.
Sorry, your point is about the word repay?
Yes.
Repay.
Yes.
Yes. And you're saying that indicates that the word pay earlier on in 42B, we can't place too much weight on it because they're interchanging pay and repay. Is that the point?
It seems to be kind of looseness in the language, which I think we submit features in this part. In terms of the main argument under section 40, subsection 2, my learned friend correctly said that one has to look at the context. when it comes to interpretation. And in relation to that, we agree entirely, and we say the context is you first look at section 40, subsection 1, and I'm not going to rehearse again the submissions. We say that that is important in that it sets, as does section 13, the limit, the jurisdictional limitation, which is one has to have a landlord who's committed an offence. But it is of interest that when it comes to section 43.3, and this is the actual making of a rent repayment order, subsection 1 specifies the first-tier tribunal may make a rent repayment order if satisfied beyond reasonable doubt that a landlord has committed an offence. So it uses the same jurisdictional filter, and then I've already highlighted in brackets whether or not the landlord has been convicted, and refers to the definite article. So our reading is that section 40, subsection 1 is of importance in analysing the case, in analysing what the jurisdictional limitations are. We don't have anything akin to section 73, subsection 10 at all. We then have the analysis, my learned friend's analysis, as to subsection 2, and I won't go over it. We say that if one looks at it through the perspective of penalisation, which this is all about, it's effectively a penalty affecting the profits of the landlord. They've got to make a payment that's referable to rent that has been paid to a tenant or amounts they've received of universal credit. And through that lens, in relation to what's been said about section 41, my learned friend, that again points to a direct relationship between the tenant, the person in the property under the who holds the tenancy of the property and pays the rent. My learned friend says that section 40, subsection 2 can only be read to say that that is the only when considering an application that can only be referable to that direct relationship. But if one looks at the wording of section 41, the introductory paragraph under subsection 1, it sets out that this is about making an application, may apply for a rent repayment order against a person who has committed an offence.
So where are you? Forgive me.
I'm sorry, it's 270. Page 270. And then subsection 2, a tenant may apply for a rent repayment order only if the offence relates to housing that at the time of the offence was let to the tenant. Well, that applies on both constructions. And then the offence was committed in the period of 12 months, ending with the day on which the application was made. So on that, on our reading of this chapter, these provisions, that is open to our interpretation, especially when one looks at it in terms of an application based on penalty. Then one comes, I've already referred to section 43, but points have been raised in relation to section 4, and it's been said that on a natural reading, the only interpretation is that one again is dealing with this relationship between the tenant and the immediate landlord. In my submission, again, one has to look at the heading. This is about the amount of the order to be paid, so it's effectively assessing quantum. And I appreciate that on a grammatical reading, one can run together section 44, subsection 3, with section 40, subsection 2. But we say this is about assessing the amount of penalty in the particular case, how you assess it, rather than in somewhat tortuous fashion dictating who is liable in relation to the rent repayment order. And the same, we say, applies in relation to section 45, which is, apologies, which is in relation to the amount payable by the local housing authority to the local housing authority, and subsection 3. Again, one's dealing with an assessment of the amount of penalty. So the amount the landlord may be required to repay rather than pay in respect of a period must not exceed the amount of universal credit that the landlord received directly or indirectly in respect of rent under the tenancy. So we say the superior landlord could indirectly be said to have received an amount in relation to universal credit in that situation. And this is about assessing the amount rather than the provision setting out who is to be captured under the legislation, which in our submission is contained very much in section 40 subsection 1, and then again in terms of the making of a rent repayment order is referred to under section 43. In relation to the overall position, we submit that the statutory context and the policy of the legislation is extremely important. And when it comes to the issue of doubtful penalisation, one ought to, and we say what's decisive, is looking at the question of the policy behind the Act and the policy behind these provisions. And if the court agrees that the target is rogue landlords, including rogue superior landlords, then the reading of these provisions should be considered in the light of that to come up with the correct meaning of the statutory provision. And again, we say that that's in accordance with what was found ultimately, though grammatically the Deputy President found otherwise to start with, but at the end of the day came to the conclusion that without a limiting provision, and there isn't one, it's a landlord, and having regard to the statutory purpose, which again is clearly stated, that this reading was the proper one and applies a common sense to the statutory provisions. The fact that there's other statutory provisions that armoury that can be brought against the superior landlord, who is a rogue landlord, is correct. But the question is whether or not the expansion of the jurisdiction with these offences, with the wording given under Section 13, that the intention or the policy was to capture all rogue landlords, rather than to stymie the effect of the provisions, and in particular in relation to improvement notices, prohibition notices and licensing offences. In our submission, it simply doesn't make any sense. If I could just have a moment.
Yes, of course.
Those are my submissions in reply.
Thank you, Mr. Fitzpatrick. Thank you, Mr. Fitzpatrick. We're grateful. Well, we will take time to consider our judgment in this very interesting and important case. We're very grateful to all counsel in the case for the very helpful submissions. And we note in particular that all counsel are appearing pro bono, matter for which we're particularly grateful. We're also grateful to those sitting behind you and all the preparation that's gone into this case, which is much appreciated. And I should also acknowledge the assistance we've received from the interveners in their written submissions. We'll take time to consider our judgment. Court's now adjourned. Thank you very much.